Good afternoon, everyone. I'm Tim Richards, Technical Services Manager of the Managing General Agents Association, and on behalf of the MGAA, I'd like to welcome you to our briefing this afternoon. This is being delivered by Clyde & Co. on the subject of the Appointed Representatives Regime, Reforms, Liability and Agency. Before I introduce our presenters, I'd just like to run through a few housekeeping points. Please ensure your microphone and camera are turned off. If you'd like to ask a question, feel free to use the chat button at the bottom of your screen. Time allowing, these will be asked and answered at the end of the event. If we run out of time, questions will be answered post-event. This presentation is accredited for CPD hours if relevant to your ongoing professional development programme. The briefing is being recorded, and a link to the recording will be issued post-event together with the slides and our feedback survey. Please take the time to complete the survey. Take no longer than 2 minutes and allows us to deliver the best possible future events to our members. So as a recap, today's briefing is on the subject of the Appointed Representatives Regime, Reforms, Liability and Agency from Clyde & Co. So let me introduce you to our presenters, Tom White and Rob Crossingham. Tom's practice focuses principally on commercial litigation and professional liability disputes arising in the insurance, property, construction and IT sectors. He has experience of handling a wide range of solicitors' liability disputes from a variety of firms, large and small, and their insurers arising out of real estate transactions and the drafting of property documents, among other things. Tom advises on a number of the country's largest firms of property professionals on risk management and professional liability issues, including, in particular, advising on high-value property valuation claims. Rob is a partner in the London office of Clyde & Co. He specialises in defending claims against professionals, particularly those involving financial or property-related matters, and advising insurers on related coverage issues. During his career, Rob has acted for a wide range of different professions, including architects, engineers, surveyors and valuers, solicitors, IT and media professionals, auctioneers, accountants, financial intermediaries, SIPP administrators, and fund managers. He has extensive experience in litigation, arbitration, adjudication, and in dealing with complaints before the Financial Ombudsman Service. He has also represented professionals in disciplinary proceedings before the ACCA, ARB, and others. So without further ado, enjoy the briefing, everyone. And Tom, over to you.
Thank you very much for the warm welcome, Tim, and hello, everybody. Thank you for joining us. So as Tim said, we're here today to talk about the Appointed Representatives Regime under the Financial Services and Markets Act. We're going to start with an overview of the regime, including a look at some reforms that were brought in at the end of last year, and having a look at the multiple principles arrangements under the relevant rules. And we're then going to talk about some of the potential liability issues that can arise in this context. So we'll start with what the regime is. We can have the next slide, please, Gareth. Thank you very much. The starting point is section 19 of FSMA. That sets out the general prohibition, which is that a person may not carry on regulated activity in the UK or purport to do so unless they are either authorised or exempt. And now there's a long list of regulated activities which come from the Regulated Activities Order. For present purposes, the relevant ones are on the slide there. It's affecting contracts of insurance, carrying out contracts of insurance, insurance risk transformation, dealing in investments as agent, which includes buying, selling or underwriting long-term insurance contracts and general insurance contracts, arranging or bringing about deals in investments, which includes arranging for another person to buy, sell or underwrite general insurance contracts or capacity at Lloyd's, assisting in the administration and performance of a contract of insurance, advising on investments, which again includes general insurance contracts, and arranging deals in contracts of insurance written at Lloyd's. So pretty much all aspects of insurance business constitute a regulated activity, as I'm sure everyone will be aware. As a result, in order to be involved in that business, you either need to be authorised or exempt, as specified by section 19 in the general prohibition. But obtaining FCA authorisation is a very burdensome exercise. It carries with it some extensive ongoing compliance obligations. And so the Act includes an alternative, namely acting as an appointed representative and then falling in with an exemption to the general prohibition as provided for in section 39 of FSMA. If we could have the next slide, Gareth, that sets out the text of that section. In order to qualify as an appointed representative, the business in question needs to be party to a contract with the principal, who is FCA authorised, and that contract needs to meet certain requirements, and the principal needs to have accepted responsibility for the appointed representative's activities. Rob's going to come back in a few minutes to the consequences of that acceptance of responsibility when we look at the liability considerations. What all this means is that the appointed representative is effectively able to benefit from the authorised status of his principal. The quid pro quo is that the principal has to accept various burdens on behalf of the appointed representative, and we'll look at those in a little more detail shortly. Currently, there are around 2,900 principals in the UK, and they have around 35,000 appointed representatives reporting into them. Appointed reps are seen most commonly in the financial advisor sector. There are about 15,300 appointed reps in what the FCA define as the consumer finance sector, around 7,500 in consumer investments as well, and together that makes up about 65% of the total appointed reps population. Many firms of independent financial advisors operate as a network arrangement where they have a central entity which is FCA regulated, and under it has lots and lots of appointed representatives, which might be sole traders, might be corporates, and they do the day-to-day work for the central body. The appointed reps regime in that scenario is used primarily to open up the availability of more distribution channels that would be than would be available if every entity had to be FCA regulated because of that burden I referred to earlier. The number of appointed reps in the insurance sector has actually been declining over the last 15 years, but there are still quite a significant number. There are 9,500 or so in the general insurance and protection sector in the FCA statistics. That's about 27% of the total number of appointed representatives overall. The regime doesn't apply to all forms of regulated activity, though, but it is likely to cover most aspects of an insurance intermediary's role. In particular, if we could look at the next slide, which actually is going back, appointed reps can be permitted to deal in investments as agents, and as I mentioned, that includes dealing in insurance contracts, arrange deals in investments, and assisted in the administration and performance of the contract of insurance. Although the intermediary won't need to be FCA regulated if acting as an appointed representative, for business of this sort relating to insurance contracts, it is necessary for it to be included on the Financial Services Register as carrying on insurance distribution activities. That is, though, much less onerous for the relevant entity than actually getting that FCA regulated status. So, as I mentioned earlier, in order to qualify for the exemption from the general prohibition, the appointed rep needs to be party to a contract with a principal which meets certain criteria. And if we could go to the next slide, we've got the relevant ones in an insurance context, which are that the agreement needs either to prohibit the appointed rep from representing other principals, or allow the principal to impose such a prohibition or impose restrictions on the other principals the AR can represent, or the types of work it can do for other principals. So an ability on the part of the principal to dictate whether the appointed rep acts for other principals, and if so, in what context, in what capacity. Or alternatively, it needs to prohibit the appointed rep from carrying out business. In addition, it needs to prohibit the appointed rep from carrying out business unless and until it's on the Financial Services Register. The contract needs to enable the principal to comply properly with any limitations on its own FCA permissions. It needs to require the appointed rep to cooperate with the FCA and to provide the principal with such information as is necessary to enable the principal to comply with its supervisory obligations under the FCA handbook, which we'll come back to in a minute. And the contract needs to give the principal the ability to terminate, in particular, if it concludes it's no longer able to effectively supervise the activities of the appointed rep. if all of those formalities are satisfied, the appointed representative relationship can get up and running. But the duties imposed by FSMA and the FCA handbook don't stop at the point of appointment, though. In particular, and importantly, the principal has extensive obligations in respect of the monitoring and supervision of its appointed representatives. It has to be able to demonstrate that it has rigorous management information so as to enable close and continuous supervision of its appointed representatives. Monitoring by a principal of its appointed reps has to be appropriate to the nature of the business of the appointed rep on an individual basis. So, for instance, an appointed rep which generates lots of work will generally require lots more supervision than a smaller entity. So you have to tailor the supervision to the particular circumstances of the particular appointed rep. Some key aspects of a principal's supervisory obligations are on our next slide. They are a requirement that the principal has to have appropriate systems and controls in place to ensure that the AR complies with its terms of its appointment. It has to check on the financial position of the appointed rep at least annually, and should take necessary action, which could be increased supervision or possibly terminating the AR relationship if there are any concerns in that regard. And the theory there is that where an appointed rep gets themselves into financial difficulty, there is a greater risk of bad things happening, things like fraud, for instance, or straying outside the boundaries of the appointed rep agreement and starting to do things which are in breach of the general prohibition. The principal also has to ensure that the appointed rep is dealing with client money appropriately, including ensuring it's properly segregated. Where functions or tasks are delegated to the appointed rep, the principal has to ensure that no conflicts of interest arise in that regard. It also has to take reasonable steps to ensure the AR doesn't carry on other regulated activities beyond the scope of its appointment with the principal in breach of the general prohibition. So there isn't a duty to closely monitor things which the appointed rep does outside the scope of its appointment, other than just generally ensuring they're not doing regulated activities for which they don't have the necessary permission. The principal has to ensure that the AR carries on its business for the principal in a way which is held out as being clearly distinct from any of the AR's other business. So again, they don't have to look closely at what else the AR is doing. They just need to make sure that it's distinguishable from what they're doing on behalf of the principal. And the principal has to ensure that the appointed reps personnel are appropriately trained and qualified for the business in question. Now, importantly for present purposes, and as we'll come back to in a minute, under section 138D of the Financial Services and Markets Act, a failure to comply with a number of these supervisory obligations is actionable by individuals. So if, for instance, there is an absence of, I'm just getting on my notes here, the appropriate systems and controls to ensure compliance on the part of the principal, then an individual who has suffered at the hands of the appointed representative may have a claim against the principal for losses that have been caused as a result. Not all of these supervisory obligations give rise to that private right of action, though. It is only systems and controls, handling of client money, ensuring that there's no breach of the general prohibition, and ensuring there's appropriate separation of the appointed rep business as compared with the appointed rep's other business. We're going to come back to that shortly as well. I mentioned at the outset that there's been some reforms to the appointed reps regime at the end of last year. The FCA had identified a wide range of harms that were being suffered across every sector in which ARs operate, and so consulted in the course of 2022 on implementing changes to address those issues. Those changes were almost all focused on the obligations of principals and the way in which they monitor and supervise appointed reps. And if we could move on to the next slide, we have some of the key features of the new rules. So now principals are required to report more to the FCA on, among other things, the primary reason for appointing the AR, the nature of the activities the AR is permitted to undertake, whether the AR will conduct non-regulated activities alongside the regulated activities, and if so, what the non-regulated activities consist of, whether the AR will provide services to retail clients, whether the AR previously acted for a different principal, and if so, why that relationship was terminated, so trying to weed out any sort of bad eggs, and the estimated revenue from the AR's regulated and non-regulated activities. The principal also has to verify information about the ARs on the Financial Services Register on an annual basis. They have to submit complaints data on the ARs to the FCA and report to the FCA annually on the revenues generated by the appointed representatives under their control, which is then compared with the estimates that are given at the outset. There's also now more emphasis on the supervision of appointed representatives. Principals are required to ensure that their controls and resources are adequate at all times. They have to oversee their employees to a comparable standard as if they were individually directly employed by the principal. And they have to review their appointed reps at least every 12 months to check on the fitness and propriety of senior management and the AR's financial position. So even more significant obligations being imposed there on principals in terms of supervision, in particular the obligation to oversee the appointed reps as if you employed them, which it seems to me is quite a lot to ask of the principal. Principals also now have to prepare a self-assessment document each year, demonstrating their compliance with the regime and the methodologies they've used in that context. As I say, that is all very onerous for principals, but it's with good reason, bearing in mind the nature of the problems and the extent of the problems that the FCA had seen in the lead up to the 2022 consultation, particularly in the consumer financial advisory context described earlier. The FCA's analysis revealed that on average, principals of ARs generate between 50% and 400% more complaints and supervisory cases than firms which don't have ARs at all. So that's quite a stark difference. The reforms have also already had a fairly significant effect on the use of the appointed reps regime. It's already been reported that there's been a 7% decline in the number of appointed representatives in the last year, just since the reforms were introduced. And that seemed very likely to be a direct result of the additional burden that's been imposed on principals. Now, just before I hand over to Rob, just a few words about multiple principals. If we could have the next slide, please, Gareth. This does raise some further considerations where the appointed rep is looking to act for more than one regulated principal. In particular, the principal or all of them aren't allowed to appoint the appointed rep until they've all entered into an agreement with each other, which is known as a multiple principal agreement. That needs to set out the relationship between the principals as well as their relationship with the appointed representative, and to include provisions aimed at protecting clients. And factors which need to be taken into account in this context include defining the scope of the AR's activities for each principal, determining which of the principals is going to be responsible for handling complaints, and regulating the arrangements in relation to supervision and monitoring of the appointed rep. There are some areas where multiple principal agreements are prohibited. Of particular relevance in the insurance context, though, is there's a prohibition on multiple principal arrangements in respect of life assurance and long-term care insurance. But that prohibition itself isn't all-encompassing. It is possible for a long-term insurer to engage in multiple principal agreements, provided that all of the other principals are long-term insurers, and so sector-specific there. So that concludes our overview of the regime, and we're now going to have a look at some of the liability issues which could be encountered, which is where I hand over to Rob.
Thank you very much. May the next slide sit. Great, thank you. So we've heard from Tom about the regime, the AR regime generally, the reforms, and importantly the requirement under section 39(1) of FSMA that the principal has to accept responsibility for the AR's acts and omissions. But what does that liability look like? How, why, and in what circumstances will a principal be liable for the acts of an AR? I'm going to spend 5 or 10 minutes really running through some of the principles of liability, focusing on the issues which have arisen under FSMA, in particular section 39(3), which is the key statutory provision. But before we go back to FSMA, it's really important to understand that there are effectively 2 layers of liability issue here, which arise when we're talking about a principal's liability for its agent, which is really what we're talking about here. Underlying the FSMA regime under section 39, there are some common law agency principles which we need to look at, and I thought that's where we'd start with this slide. An agent will very often and always here in the FCA regulated context have express authority to undertake the role for which they've been employed, perhaps as a result of an employment contract, as a result of instructions which they've been given by a supervisor, and as Tom says, always here as a result of section 39(1, there will be an AR agreement which deals with express authority and defines the scope of the agent's role. But there'll be some cases where authority is not expressly given, but where liability for the principal arises anyway. And in those cases, clearly there's room for dispute and doubt. Where does the agent's authority come from? What's the scope of their authority? And how does that give rise to liability for the principal? So as I say, before we get back to FSMA and section 39, let's look at some of the common law principles that arise. And there really are 2 of them, I think, that are particularly relevant. One is implied authority, and the other is ostensible authority. With implied authority, the point is this: an agent has implied authority to do whatever is necessary for or ordinarily incidental to the effective execution of his or her express authority in the usual way. And that gives rise to a liability on the part of the principal for acts or missions committed by the agent as incidental to their role. So some examples of that might be in the FCA context, where, say, an AR has express authority to give investment advice. As a result, they will have authority also to undertake regulated activities such as undertaking fact finds and looking at attitude to risk and liaising with product providers about the particular characteristics or benefits of a particular investment product. And all of those activities will fall within the express authority as being necessary or incidental to the primary role. And you see that example play out in this case of Martin and Britannia Life, which dates back a bit now. And in that case, the AR had authority to advise on investments. But they also gave advice to clients on a mortgage. And the question clearly was, although the mortgage was not considered an investment, it was outside the strict scope of the authority which had been given by the principal in relation to investments. It was held in that case that the AR had actual authority to give mortgage advice insofar as it was inherently bound up with and incidental to the advice given in relation to investment. So the principal would have liability for the mortgage advice given by the AR, even though it hadn't expressly dealt with it in the contractual arrangements between it and its principal. Secondly, ostensible authority. The common law principle of ostensible authority can often raise really difficult issues for principals, and particularly in the FCA regulated context. And the principle really is this, that if the customer is given the impression that the AR has the principal's authority to undertake a particular type of business, even if the AR does not have that authority, the principal may still be bound. And really this, I think, as a matter of law, I suppose, is viewed as a type of estoppel, where a representation is considered to be made by the principal, even if inadvertently, and the customer then relies on it. The principal is estopped or prevented from saying that there was no authority. And again, an example of this is Martin Britannia Life, where the principal had given the AR a business card, which referred to the AR as financial advisor. And this was held to lead to a liability far wider than the principal had authorised. The principal was liable as the AR had ostensible or apparent authority for the work which had been undertaken, even though it was outside the express and agreed scope of their role under the AR agreement. So that type of situation's got danger written all over it, seems to me. And to summarise then on the common law, we've got two things to worry about. One is implied authority, where the AR is doing things that aren't directly within the scope of their authorisation under the AR agreement, but those things are nevertheless incidental to or inherently bound up with that role. That's implied authority. And the second thing to worry about is, probably more so in fact, is this issue of ostensible authority or apparent authority, where the principal will have liability for things which the consumer reasonably sees as being within the AR's authority. So with that in mind, it seems to me, from a risk management point of view, that principals really need to ensure that they're clear on their and their AR's websites and perhaps a bit old school, but on business cards issued to ARs as to the scope of the AR's authority, and express warnings are never a bad idea. So moving on to the next slide then, and back into Financial Services and Markets Act regime. We'll have a look at section 39.3, which is there at the top, and we'll let that sink in. The principal of an AR is responsible to the same extent as if he'd expressly permitted it, for anything done or omitted by the AR in the carrying out on of business for which he's accepted responsibility. So we've got three things that we can tease out of that section 39.3 provision. One is the attribution of liability to the principal. The principal of an AR is responsible, so the principal is liable for the Agents Act. And then we've got a fiction, an allocation of authority to the same extent as if he'd expressly permitted it. In other words, he doesn't have to expressly permit it, provided he's got an agreement, and that's the third part, the AR agreement, business for which he's accepted responsibility. There's been quite a lot of case law around this provision, and I think we're probably now, after 23, nearly 24 years, in a fairly good position to say that we're confident about what it all means. So let's just dive into these cases to give us some examples. Emmanuel and DBS management was in fact a case that arose before FSMA came into force. It was a case that was decided under similar provisions under the Financial Services Act 1988 and the FINBA rules, but the principles are the same. Here, DBS management was the principal of an AR and Emmanuel was the claimant. And the claimant had been persuaded by the AR, who wasn't an AR at this time, been persuaded by the AR, which is called ITIP, to invest £40,000 into ITIP, which the claimant did. Later, ITIP became an AR of DBS, the defendant in this case, in respect of investment business. And subsequently, the claimant was then persuaded by ITIP's director to enter into a further investment of another £45,000. You can kind of see this coming, but ITIP became insolvent and the claimant sued DBS on the basis that it was ITIP's principal and was therefore liable for ITIP's actions to the extent that as if it had expressly permitted it. And what's interesting is that the claim was struck out. A common law principal was not responsible for the wrongs of an agent who was not an employee but an independent contractor. So that dealt with common law concerns. Secondly, under the FINBA rules, which are equivalent of the rules which are currently in force, the principal assumed liability for all acts of the AR in the course of acting as such, i.e. business for which the principal had accepted responsibility, but not otherwise. And there was no liability under the Act in respect to the first transaction, which was the transaction that took place before DBS became ITIP's principal. And the reason being that the AR agreement wasn't enforced then. So there's a question of timing there, that acts done prior to or after the AR relationship comes to an end do not fall within that principal liability. And finally, with Emmanuel and DBS, the advice which was given to the claimant to invest in the AR was deemed to be outside the scope of the AR agreement. It wasn't investment business, it was a commercial transaction giving rise to a loan to the agent. So two key takeaways from that. One, timing. If an act is complained about against the principal, which doesn't relate to the period when they were an agent's principal, then the principal won't be liable. And similarly, if it's outside the scope of the agreement, then the principal won't be liable. So that's Emmanuel and DBS. Ovcharenko and Invest UK, slightly more straightforward, really. This was a case where the agent had arranged investments of £250,000 for the claimants in order for them to obtain a UK visa. Inevitably, the claimants lost their money. They claimed against both the agent and the principal. And it was held in that case that because the agent had authority under the AR agreement to conduct investment business, this claim felt squarely within the Section 39 principle, because the principal was liable for the agent's acts to the same extent as if they'd done it themselves, and it was squarely within that Section 39.1 contract. So that's Ovcharenko, fairly straightforward. Finally, then, Anderson and Sense Network, which really now I would see is the main case on liability for ARs. In this case, Midas was the agent, the AR, and the principal was Sense Networks. There were 95 investors who brought a claim against Midas and Sense in connection with an investment scheme that was promoted by Midas in 2007. Sense, as Tom has said in the outline of the regime, Sense was obliged under the FCA rules to supervise Midas as an AR. But what was interesting here was that Midas hid its involvement in this particular Ponzi scheme from Sense until Midas's training supervisor blew the whistle. Sense then immediately terminated its relationship with Midas. The investors, 95 of them, sued Sense on the basis that under Section 39.3 it had accepted liability as a result of the AR agreement. What's really interesting, again, perhaps chiming with Emmanuel and DBS here, is that the claim was struck out, it didn't succeed. As a matter of principle and analysis, when you're looking at this type of arrangement, the court said, you need to start by looking at the AR agreement, and really you need to draw the link between what's said in the agreement and the liability that's being claimed under Section 39.3. So Section 39.1 agreement and the Section 39.3 liability need to be coextensive. So the starting point, look at the AR agreement. Second of all, it was wrong for the claimants to approach it on the basis that the principal had given generic authority to the agent to conduct its business. Again, you had to look at the AR agreement to see precisely what authority had been given in respect of which types of business. And importantly, principals can limit the scope of the type of business for which they accept responsibility. So again, big risk management point there. Thirdly, in order to establish liability under Section 39, the terms of the AR agreement had to be scrutinised. And in this case, it contained a restriction, a limitation on what Midas could do. And needless to say, in promoting a Ponzi scheme, Midas had stepped outside what Sense had said it could do. So again, risk management, it is absolutely okay and very good idea to limit the scope of that authority. Finally, going back to the common law analysis, the judge in Anderson and Sense said, well, as a matter of common law, there will only be vicarious liability where the acts are within the scope of the principal's authority. Here, Midas had gone off on a frolic of its own, and there was no vicarious liability. So I think lots to learn from Anderson and Sense. If we then have a very brief look at Section 39.4, which looks rather like Section 39.3, the distinction here is that Section 39.4 enables the FCA to take into account the acts of the agent, acts or omissions of the agent, when considering whether the principal has breached their regulatory requirements. It seems to me a fairly significant risk arises under Section 39.4, even though not a civil liability risk, as in Section 39.3. Nevertheless, it does very much open up the door for the FCA to come breathing down the principal's neck in circumstances where the AR has breached their regulatory obligations. So that is Section 39.3 and Section 39.4. There are some, moving on to the next and final slide from me, sweep up, if you like, liability considerations, which I thought I'd flag. The first is Section 27 of FSMA, which I think is a real worry, perhaps not so much in the general insurance sector, but certainly in the investment sector. Section 27 applies to a situation where an agreement is made by an authorised person as a result of an unauthorised person giving regulated advice in breach of the general prohibition. And the paradigm situation with this is where a regulated firm deals with an unregulated introducer. The unregulated introducer typically will arrange fact finds and sometimes give advice before the reference is made to the regulated entity. And that is a paradigm situation where Section 27 will apply, because you've got an unregulated introducer acting in breach of the general prohibition, for which the regulated entity where it takes a part in this general arrangement will be liable to unwind the whole transaction and compensate the investor. And as I say, you see this a lot in particularly pensions, where there were client farming unregulated introducers going around doing fact finds and then simply passing the business over to a regulated entity to proceed with the transaction, and the regulated entity is left with this enormous liability, effectively, to unwind the whole arrangement and provide compensation. So that's a worry, it seems to me. Finally, a general provision which Tom has already touched on, and this is Section 138D, which has been around for a very long time, and pre-FSMA 2000, it went back to the earlier iterations of the Financial Services Act. And this gives rise to a broad liability exposure where there's been a breach of any FCA rule which has caused a loss. It gives rise to a statutory cause of action, which we saw in the Ovcharenko case being relied on. It could, it seems to me, apply directly against the principal where there's, say, been a failure to supervise the AR, which has caused the claimant a loss. And again, that was an allegation which was made in the cases that we've talked about. So general statutory civil liability under Section 38D for breach of any FCA rule which causes a loss. There are some pretty reasonable defences available to that, because of course it embeds within it the concept of causation. So if the breach has not caused a loss, then it seems to me that there'll be a good causation defence. And similarly, the reference to an FCA rule has fairly recently been held to mean a rule, not a guidance or a Dear CEO letter. So Section 138D is of broad application and of concern, but there are reasonable responses to it which are often met with some success. So to summarise, before handing back to Tom, we've looked at some common law principles which might give rise to a principal's liability for its agents, including implied authority and ostensible authority. We've looked at Section 39(3), which gives rise to a statutory form of vicarious liability, very extensive statutory form of vicarious liability in the AR context. And we've looked at some specific liabilities and causes of action which arise under FSMA, which undoubtedly raise issues of concern. So I'll pass back to Tom, who's going to draw, I think, everything together in an example, a case in which he was involved.
Yes, thanks very much, Robert. So I've just got a couple of war stories from cases I've been involved in which illustrate the sort of points that we've been talking about. The first of those related to a claim against a well-known firm of independent financial advisors, none other than St James's Place. It's in the public domain, so I can say a bit more about it than I might otherwise be able to. We were acting for Andy Townsend, the former professional footballer, and a group of other former professional footballers and other colleagues of theirs as well, in a claim relating to financial advice given to them by an appointed representative of SJP. Now, SJP operates as a network, as I described earlier, where there's a PLC at the centre, but its distribution channels are all through appointed representatives, either sole traders or corporates who work beneath the PLC. Our case related to one of the most long-standing SJP appointed representatives who had gone rogue. The setup at SJP is supposed to be that the appointed reps are only allowed to advise on SJP investment products. They're really just selling whatever it is that SJP puts together. But the individual that we were dealing with managed to get his clients into all sorts of other products. There was a film finance scheme involved, investments in a Caribbean holiday resort project called Harlequin Properties, and you can probably guess what happened. The film finance scheme, which was supposed to be a tax break, didn't work. Harlequin turned out to be a massive fraud. You might have seen in the press recently that the man at the centre of the Harlequin scheme has now been sent to prison. As a result, our clients lost most of their pension funds, which is obviously a major problem for a retired professional footballer, where you retire young, having earned big in your early years, and then hope to live off the pension for the remainder of your time. The rogue advisor predictably wasn't worth pursuing in his own right, so we needed to go against SJP to see if we could get some form of recovery from them. And we had all sorts of different angles to our claim. We asserted that SJP had given actual authority to the rogue advisor to sell the products which were the subject of the claim. And there was an AR agreement in place for the advisor, which did purport to limit his actual authority. But that agreement dated back to the 1990s, before SJP actually existed. It was with a different legal entity. So instead we were able to rely on other evidence from SJP's records, showing that the firm knew what this rogue advisor was up to, and that he was touting other investments around, and gave implicit actual authority, as Rob was describing earlier, for him to do that. We also asserted a claim based on ostensible authority on the premise that the rogue advisor had been doing everything under an SJP banner, and SJP implicitly allowed him to do so, again tying back to their knowledge of what he was doing. He even referred to himself as Mr. SJP when talking to clients about investments in these wacky get-rich-quick schemes. And we had a claim against the SJP under Section 39 of FSMA. Although because we had that AR agreement, which I referred to, was very significantly out of date and inapplicable, we had a problem with identifying the scope of any assumption of responsibility on the part of SJP. But SJP did accept that it was responsible for the rogue advisor insofar as he was dealing with SJP products. Now that enabled us then to say that where the advisor was getting the clients to take their money out of an SJP product and invested in some harebrained scheme that he came up with, SJP would have to bear the consequences of that because they were so closely linked. It's the Martin Britannia Life Authority that Rob referred to, the proposition that it's not possible to draw a dividing line between selling products which are within the scope of the authority and then using the proceeds to buy something unsuitable, which is outside the authority, where there is a connection between those two, where the sale is for the purposes of generating proceeds to invest in the next product. The other line of claim which we had against SJP, which at least I thought was our strongest, was under the private right of action under Section 138D of FSMA, based on the monitoring and supervising of this rogue individual. That issue was hotly contested because SJP argued that it had a very sophisticated and rigorous supervisory setup. That was true at a general level, at least. It's obviously a big organisation with lots of resource available to it. But once we delved into the evidence of what happened in respect of this particular individual and how he was supervised on an individual basis, that gave us quite a lot of helpful material. It seemed pretty clear that he was taking liberties within SJP and that SJP knew what was going on and gave him special treatment. SJP tried to argue that they didn't know what the rogue was up to because he continually gave them late, limited and generic information about his activities, to which we said, well, why did that not ring a massive alarm bell that he was probably doing something up to no good? It also didn't help SJP when we identified that the rogue advisor had sold an investment in the fraudulent Harlequin scheme to his own supervisor at SJP, and that once complaints started coming in, the rogue advisor was very quietly exited from the business. So, as you can probably guess, we had quite a lot of fun in picking holes in what was actually going on within SJP in relation to this particular bad egg. So it wasn't just a question of what was the supervisory structure and setup. It was did it actually work and was it properly operated in relation to this one individual? Another issue I've encountered recently on a case relating to appointed reps is, I think at least it's quite an interesting point, which is what should happen if the AR agreement mistakenly doesn't reflect what both the principal and the AR intended in relation to the assumption of responsibility. So you could have, for instance, an arrangement which was supposed to be a limited assumption of responsibility on the part of the principal, where they were saying, we will authorise you to do this part of this particular type of business and will accept responsibility for that only, whereas the agreement itself suggests something much broader and will authorise you to do all sorts of different types of business and will accept responsibility for everything. Now, an AR agreement is a contract like any other, and so in theory it ought to be possible to apply to the court to rectify the agreement where the wording doesn't reflect the party's true intentions by reason of a mistake. Rectification has retrospective effects. So then the question would be, if the AR is alleged to have done something wrong, and if that something is within the assumption of responsibility according to the wording of the contract, but beyond what was intended by principal and AR jointly, can the third party still have a cause of action against the principal, which relies on the wording of the contract, even though that wording is wrong? Or can that be cut off if the AR agreement is rectified? The third party claimant won't have known about the terms of the appointed rep agreement at the time of entering into whatever transaction leads to the loss. So they can't say that they were prejudiced by a retrospective rectification of that agreement because they weren't relying on it at all. In theory, I think that ought to work. It ought to be possible for the principal and the AR potentially jointly to apply to the court to rectify their agreement and thereby preclude claims by third parties against a principal. But there isn't any authority on that issue at the moment. I don't doubt that at some point it will come before the court, it will be tested, and so we'll have to see where it lands if that does happen. That brings us to the end of our presentation. If we just look back and reflect on the learning objectives on our next slide. So we've talked about the context, which is mainly ARs being used to increase the variety of distribution channels available to financial services businesses. And we've given an overview of the appointed reps regime, particularly looking at the obligations at the point of appointment of appointed representatives and thereafter in terms of supervision and monitoring. We've talked about the recent reforms to the regime, the driver for those changes being significant harms that are being experienced across the board, and the risk issues which arise for ARs and their principals. We've looked at multiple principal agreements, the need to regulate the arrangements both between principal and AR and also between principal and principal. And we've looked in quite some detail at the liability considerations, in particular for principals and how they might be liable either under current common law agency principles or under the Act by virtue of the obligation to stand behind the appointed rep in accordance with the appointed rep agreement. So hopefully we have fulfilled our learning objectives. I've seen that there's some questions that have come up on the screen, although I haven't been able to read any of them yet. Tim, should we hand back to you?
Yeah, absolutely. Thanks both. We do have a couple of questions as you mentioned. So first of those is, could a similar transfer of liability apply to principal in the event AR becomes insolvent?
Yes. So most of the authorities in this area and the cases that I've just referred to arise in a situation where the AR is either insolvent or it's just not worth pursuing because they don't have sufficient assets. The principal will, generally speaking, be the big corporates with deep pockets, and so what the claimant will be looking for is a route through to bypass the AR because it's got no money and to get through to the principal. So quite often the solvency or otherwise of the AR is the driver for these cases which have tested the scope of the principles we talked about in terms of agency and the assumption of responsibility under FSMA.
Well, that's precisely what happened in Emmanuel and DBS.
Great, thank you. And there's one more question here. So if anyone does have any other questions, do feel free to add them to the chat. We do have around about 10 minutes left, but the last question for the moment is, how is the regulatory principles liability impacted where their AR acts as a cover holder? Sorry, I just had another question in which moved that up. Where their AR acts as a cover holder for an insurer, i.e. when carrying out regulated activity, it also acts as cover holder under a binder with an insurer using the regulatory principles permissions.
So if I've understood the question correctly, I'd have thought that the principal in that relationship will be assuming responsibility for the entirety of the AR's activities, including the aspects of acting as a cover holder. I'm not sure whether that quite answers the question, though. I don't know if we can see the question on the chat. That might help with them.
Shall I read it again? It's how is the regulatory principles liability impacted where their AR acts as a cover holder for an insurer, i.e. when carrying out a regulated activity, it also acts as cover holder under a binder with an insurer using the regulatory principles permissions?
Yeah, I think the point would be that the principal would be assuming responsibility for everything that the AR does. And so if something were to go wrong in the cover holder capacity, then the principal would be at risk.
I suppose there are probably, as ever with this kind of situation, it depends very greatly on the precise arrangements that are in place. And I think primarily, if we're thinking about liability under Section 39(3), it's right, isn't it, that's the regime we're dealing with, as Tom said. But I suppose, depending on the facts, there might be common law issues as between the underlying insurer and the agent acting as cover holder. So some of those common law principles might apply to the other limb of that tripartite arrangement.
And next question here. Sorry, did I interrupt?
Sorry, my name's Neda Villas. I asked the last question.
Please.
I asked the last question. I guess the issue here is that the appointed representative effectively would have two principles, wouldn't they? Because they'd be using, the regulatory principles license to carry out regulated activity, but then has a binding authority in place where it's delegated authority to underwrite insurances on behalf of the insurers. Effectively, we've got a situation where you've got an AR that has two principles. That's really the scenario that I was trying to outline here, and therefore trying to then understand how responsibility would be apportioned between the two principles in those circumstances.
I understand. Thank you for the question. If it really was an arrangement which did involve more than one principle, then what should be happening is that there should be one of those multiple principal agreements that I mentioned earlier in place. And that agreement would be, at least under the Act, what dictates where the liability sits if something goes wrong, as between the two different potential principles. I'd have thought it would be in the immediate principle as opposed to the sort of the capacity provider sitting above them. But obviously that depends on what is said in the document itself. And then you would have to overlay that with the common law agency principles, which involves looking at the way in which the AR operated, who it was held out as representing in that context, whether that could be said to be giving rise to direct agency relationship with the insurer at the top of the chain, as it were, or only with the intermediate principle. So very typically in this line of work, the answer is it depends. But hopefully that gives an idea of the factors that will determine what it depends on.
Right. Okay, thank you.
Thanks for the question, Hash. And I've got two more questions, which I think we've just about got time to squeeze in. So the first of those is new AR agreements will require us to be able to terminate if we, as the principal, cannot adequately supervise the AR. What sort of notice period should we be looking at, or should it be immediate? It seems unreasonable to reserve the right to terminate at will without notice, as it prevents the AR from planning its business.
I think it does need to be an ability to terminate at will. Immediately, I should say, because, for instance, if you were to identify in one of the annual checkups a major issue with the AR, such as them being insolvent or some concern about fraudulent activity or something of that sort, you need to have the ability to stop that straight away, so as to prevent harm coming to consumers in particular, or other customers of the business. So I think I accept the point about that being difficult for the AR, but I think the principal does need to have the ability to exert that level of control in order to avoid getting themselves into difficulty, either with a regulator or with third parties who are engaging with the AR.
Great, and I've actually got two questions because I've just had a new one, so hopefully we can just about cram those in. So the first of those are there any example of ARs of MGA businesses which have gone wrong?
Undoubtedly very many, yes.
We can't name names.
Okay, and the last question for the moment then, what enhanced oversight can ARs expect to have from principals to help principals manage their cover holder MGA ARs?
So the enhanced oversight by principals of their ARs, or there has been an enhancement required by the December 2022 reforms. A lot of it is around the flow of information to the principal, and the need for them to make inquiries of the AR in order to ensure that they are getting that information from them. And it's quite prescriptive in the rules that now apply since the end of last year, and there is effectively a list of questions that need to be asked about things like the reasons for the appointment, the nature of the activities being undertaken, etc., the reasons for any termination of a prior relationship, etc. So the rules are pretty fulsome in terms of identifying what has to be obtained. It looked like there were some follow-up points on that question that came up on screen there.
There are a couple of other questions. Let's see if we can just cover one of them. So are there set requirements templates for the annual internal AR reports principals must do? Assume this is separate to annual FCA attestations via Reg RMAR, etc.
It will be separate, and there will be set contents for it. Whether there's an actual template, I couldn't tell you off the top of my head. But as I say, the rules generally are pretty prescriptive.
Okay, one final question, and I think we're right out of time then. In the earlier question, termination, in the event no continuity for AR after termination by principal, does the principal open themselves up to involuntary duty to employees of AR under TUPE?
Oh, pass. TUPE is beyond my expertise. I don't know if you want to venture a view on that.
I wouldn't have thought so, but again, yeah, it's outside the scope of bits, and I think it probably depends again.
Okay, thanks, gents. Let's leave it there because we're right out of time. Thanks for all your questions. Much appreciated, and thanks so much to Tom and Rob for your session today, which I'm sure everyone will agree has been very engaging. You can reach both Tom and Rob at the contact details shown, or feel free to contact me at tim.richards@mgaa.co.uk with any questions or introductions, and I'll be happy to pass these on. Thanks also to all of you for joining us. Please don't forget to provide your feedback and do look out for forthcoming MGAA events. As always, I do hope you have a productive afternoon. Thanks again for joining us, and see you all soon.
Thank you.
Thank you, everyone.
Thanks all.